You're listening to the Quint's podcast.
Amazon Prime's Tandav, a 9-episode political thriller TV series, which began streaming online in mid-January 2021, and ever since its release, it has received a ton of backlash from different parts of the country, especially in the form of 13 FIRs filed against Aparna Purohit, Amazon Prime Video's India creative head, the creators of the show, and also the cast, which includes the likes of Saif Ali Khan, Dimple Kapadia, Mohammad Zishan Ayub, and Sunil Grover. Now, the Supreme Court on 5th March granted interim protection from arrest to Aparna Purohit, stating that she will not be arrested provided she cooperates with the investigations. But early on 25th February, an Allahabad High Court single-judge bench rejected the anticipatory bail plea filed by Purohit for allegedly promoting religious enmity, and further stating in its 20-page order that, and I quote, "The conduct of the applicant shows that she has scant respect for the law of the land, and her conduct further disentitles her to any relief from this court." So for today's episode, we'll go through what the entire Tandav case is about, what the Allahabad High Court judgment said, what the Supreme Court ruling was about today, and what's next for the case. To discuss all this, I spoke to Karan, who is a legal consultant for the Quint and has been following the case from the start. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you, and I'm your host, Himmat. So, Karan, I don't think a lot of people know, but you're one of the newest employees at the Quint. How is it going so far?
So far, so good. I'm not complaining at all.
So, okay. I think one of the first cases that you did report on, or actually, let's tell people what you do at the Quint. I think that's more important right now. What do you do at the Quint? What's your role?
I'm helping the editorial team with the legal content, so you can sort of call me a legal consultant for the editorial team. Yeah, it's a very interesting, fascinating job because I get to both report what's happening in the courts and in the legal fraternity, and at the same time also get to wear my lawyer's hat and analyze it critically, and you know, put these legal analysis, long form legal analysis out there. So I think it's a balance of both, and I'm really enjoying it.
Okay, great. So, Karan, we are here to talk about the Amazon Prime show Tandav, which has invited a lot of fans, critics, and also quite a lot of FIRs as well. That too, just within 24 hours into its release. So let's situate ourselves as well, and also our listeners, into what exactly the controversy is, and what the controversy is about, and then move on into the case and the FIRs which have been lodged against it. So can you take me through what the controversy is about?
Yes. I mean, I myself was got aware of quote unquote controversy when I got to know that there's so many FIRs being registered. I mean, 13 FIRs across 7 states, to be precise, against this particular show, against the director, producer, one particular actor, and Aparna Purohit, who's the India head of Amazon Prime Video. I didn't watch the show before that, but after this thing sort of blew up, I went and I watched the show, and I sort of trying to understand what is the controversy about. And then I got to know that the controversy was about a particular scene, which there is a dramatization, like a Nukkad Natak, or a street show, where there is a character of Lord Shiva and there's a character of Narad, the sage Narad, and they are having a conversation about the current political scenario of the country, from protest to lynching to rising communal tensions and intolerance, and the two gods, which is Lord Shiva and Lord Ram, have been posed in a modern context, and they have been asked to comment on what is happening, what is going on in the country, as well as what is going on in their name, as to what people are doing by invoking them, what their quote unquote supporters are doing. So politicization of religion was one of the aspects, innuendos and aspects that were there in the scenes. But as the controversy sort of blew up and multiple FIRs were registered, you very rightly pointed out that all of these FIRs were registered in a very small period of time. So which also sort of makes it very fascinating that how come people separated by boundaries and people separated by different states got offended by a particular content within just hours, and then again decided to file FIRs within hours. So this timing, this accuracy of timing of people across states getting offended and then moving to police stations and filing FIRs also sort of raised eyebrows, which unfortunately no court thought of looking into.
Yeah.
Um, yes.
So the states which have from where the FIRs have been registered are from, like, I believe, Uttar Pradesh, Madhya Pradesh, Karnataka, Maharashtra, and Delhi. Or,
Yes,
or
yes,
am I
yes,
missing
you're
some
right. There are seven states.
seven?
There's 7 states in which the 13 FIRs in total have been registered, and
Hmm.
some of those FIRs, as you rightly pointed out, in Uttar Pradesh, in Madhya Pradesh, you have one in Delhi, you have in Himachal Pradesh also,
Hmm.
uh, and these FIRs invoke. I mean, these FIRs are almost similar in both the offenses that they invoke, as
Hmm.
well as what are they aggrieved by, what is the bone of contention um, in these FIRs is almost identical in all of these 13 FIRs, which again raises eyebrows. So I will just tell you as to what are the major
Yeah,
offenses that
yeah,
these.
you can take us through the major grievances voiced in these complaints. That'll be great. Yeah.
Yeah, so I think the major offenses that these FIRs raise are Section 295A, 153A1,
Hmm.
5051B, and 5052 of the
Hmm.
Indian Penal Code, which basically are the offenses that talk about deliberately and maliciously creating enmity against religious groups, or
Hmm.
deliberately and maliciously or intentionally outraging the religious beliefs, or publishing something that induces people to commit crime against the state or
Hmm.
against public tranquility. And then you have a couple of provisions from the Information Technology Act that have been invoked, like Section 66 and 67, which is
Okay.
slightly problematic because the FIR doesn't mention which part of Section 66 or 67 have been invoked, which is very important to point out here because, as we all know, that in landmark judgment of Shreya Singhal versus Union
Hmm.
of India, the Supreme Court had struck down Section 66A of the Information Technology Act as being
Hmm.
unconstitutional. But we have seen that despite the Supreme Court's judgment in Shreya Singhal, we see instances of police still invoking Section 66A to put people behind bars. So that also is very fascinating part that courts missed in this particular case. Uh,
Okay. So from what I've gathered also about the case, following the case since its beginning, uh, the biggest news breaking one about judgment was the Allahabad High Court, where it rejected the anticipatory bail against Aparna Purohit, the Amazon Prime Video's India head of development. So, can you take us through what the Allahabad HC order said exactly, and
yeah,
what was the judgment about?
yeah. I mean, it's a very unfortunate judgment to begin with. Um,
Hmm.
I mean, I was going through Twitter and I saw someone saying that it is literally a political rant with a citation. So you can see the experts, the people from the fraternity, as well as people outside the fraternity having strong views against not just what the judgment holds in terms of
Hmm.
of its order, but also the language used by the court to express its order and express its reasoning is also something that people have criticized. But before
Hmm.
that, Himmat, I would just like to quickly go through that what were the major allegations against Aparna Purohit before Allahabad High Court
Sure.
in that FIR. And so the allegations are that the particular show is adversely affecting the image of Uttar Pradesh police. Hindu
Hmm.
gods and goddesses have been depicted in bad light with the intention of inciting communal sentiments.
Hmm.
Uh, the post of prime minister has been depicted in a manner that will adversely affect the democratic system of the country.
Hmm.
And utterances have been made against the state police, public administration, and the constitutional posts so that the element of hate is developed between the communities. Now, very quickly, I just want to point out that though the offenses that have been invoked in the FIR are about religious enmity or
Hmm.
outraging the religious belief or creating hatred between religious groups, In the FIR, we see that the people are aggrieved by the depiction of political leaders, like the prime minister and the chief minister. So I sort of fail to understand as to how commenting on the prime minister or commenting on the chief minister would amount to outraging religious belief or creating hatred between religious groups. I fail to draw that link at all. I mean, it's beyond me. Or maybe people are suggesting that there is a link between a particular religion and the post of prime minister and the chief minister, but I don't know. So this is the background in which the bench of Justice Siddharth at Allahabad High Court took up this matter, and 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 then after reserving its order when the judgment came out, he denied anticipatory bail to Aparna Purohit. Uh, but before this Allahabad High Court order, yeah, so this is the background. These are the offenses and these are the facts that were presented before the Allahabad High Court, before the bench of Justice Siddharth, who adjudicated upon this matter and eventually denied anticipatory bail to Aparna Purohit. But before we came to Allahabad High Court, we have to go back to the Supreme Court, and I will quickly take you back to Supreme Court when on 27th January, Supreme Court had denied the request of Aparna Purohit and other makers of the Tandav show for clubbing the FIRs that were registered against them in various states. And so the basic argument before the Supreme Court back then was that there are that Aparna Purohit or the other defendants are the residents of Bombay, and it is highly unfair to expect them to go to every small district in Uttar Pradesh and Madhya Pradesh to file anticipatory bail. So they said that it is only to uphold her fundamental right to freedom and speech and expression, to grant her relief of clubbing all the FIRs and transferring all the FIRs to one police station. Uh,
Okay.
and secondly, they wanted interim protection from arrest because they tomorrow any police can come and arrest her, so we need to protect that. But the
Yeah.
Supreme Court denied both the reliefs, and Supreme
Okay.
Court and this is very surprising because exactly the same relief was provided to Arnab Goswami and Amish Devgan
So
in both of.
what was the reasoning, legal reasoning that the Supreme Court gave?
So Supreme Court first of all said that they cannot exercise that power of quashing FIRs, which is usually done under Section 482 of the Criminal Procedure Code. So Supreme Court said that under Section 482 of Criminal Procedure Code, it is the High Court that has the power to quash the FIRs or quash the criminal case. And as a Supreme Court, you can't exercise that power. And second, Supreme Court said that no, we don't feel inclined to transfer the FIRs to one police station and to grant you interim protection because religious sentiments have been hurt. The Supreme Court was of the opinion that there is a prima facie hurting of religious sentiment in this case. So Supreme Court sort of denied the relief in this particular case, but exactly the similar relief was provided in the cases of Arnab Goswami and Mr. Devgan, Amish Devgan. So that's why Supreme Court gave them liberty to move the high courts and take appropriate action there. So Aparna Purohit, that's why came to Allahabad High Court and filed this anticipatory bail petition.
Yeah.
And after the hearing, the petition got rejected. So this is the journey that this particular case had to take from Supreme Court to High Court and now back to Supreme Court.
Okay. So the judgment was a 20-page judgment, basically. But can you give us the highlights of what the judgment was?
Yes, I mean it was a 20-page judgment with 6 paragraphs dedicated to freedom of religion, but not a single paragraph dedicated to freedom of speech and expression. Which is a telling account of the judicial reasoning in this particular case, and which is also fascinating because in a bail matter, when you are adjudicating bail, the rights that you have to balance is the police's right to investigate and the accused's right to liberty. These are the two contrasting or conflicting rights that a judge who's adjudicating bail has to sort of balance, right? And while balancing these both rights, the principle is that bail is the rule and jail is the exception.
Okay.
that police's right to investigate is not a fundamental right, but a person's right to liberty is a fundamental right, and therefore therefore the rule is the bail and the jail is the exception. And also there are multiple principles on which bail adjudication has to happen. First of all is you have to see whether the offense is serious. So seriousness of the offense is calculated at Arnesh Kumar versus State of Bihar. It said that offenses which are punishable with 7 years or of more imprisonment would be termed as serious offenses, which is not the case in this particular matter. Like her offenses are punishable maximal by 2 years of imprisonment and or fine or both. So even the court can say, fine, we will not send you to jail, but you can just pay fine. So it's not a serious offense. Second thing that you have to look at is whether there's a flight risk, whether if given bail, this person would flee the investigation or flee the justice, which is also not the case in the present case, because Aparna Purohit said that she will comply to any conditions that is put upon her liberty if granted bail. And third is tampering of evidence, that whether if released on bail, this person will tamper the evidence or sort of influence the witnesses, which is also highly unlikely in the case, because here the evidence is only not produced. Like, we don't know what the evidence is, right? Like when you're saying that religious hatred has been created or religious beliefs have been outraged, how do you give evidence of that? So the evidence of that can be that there was a riot, or there was a fighting between two communities, or abusing or tensions between two communities, but none of that evidence was produced.
Tranquility was being disturbed, or
exactly, like public tranquility being disturbed,
but a crime was being committed, anything like which requires I think, which are the legal provisions for those charges that she's been charged with, right?
Exactly. So you have to sort of give some evidence of public tranquility being disturbed or riots happening, but none of that is there. And even if there is that evidence, how can you expect Aparna Purohit to influence that or tamper with that? Because these are cognitive evidence, right? So I mean, these are the discussions that a bail order should have, but completely absent in these 20 pages. So I mean, at that point, you would ask yourself, okay, then what is there in this order?
Yeah.
Like, doesn't it sort of raise a curiosity? Like, if it doesn't have the evidence, if it doesn't have the principles of the bail, then what is there in this order?
Okay, so I'm interested now. What is exactly in the order as well?
Yeah, and that's what motivated me to read those 20 pages again and again. And then when I read those 20 pages, all that I could find are ranting, like, or what I actually called in one of the analysis that I wrote for the Quint is an ideologically laden political commentary. And why I call it an ideologically laden political commentary is because the author here uses terminologies which actually amount to creating us versus them, where it presupposes that the religious sentiments of the majority community have been hurt. The court sort of puts itself as a custodian of the majority community. The judge giving this order assumes the role of the custodian of the majority community and passes this diktat that yes, our sentiments have been hurt, but and completely overlooks the arguments made by the other party. So you see that there is and the best example of it being an ideologically laden political commentary is in one of the paragraphs. The court actually goes on to say, and I quote, that the forces inimical to the interest of this country become active, and they make it an issue and raise it before different national and international forums, alleging that the Indian citizens have become intolerant and India has become an unsafe place to live. Even in the liberal democracies of the West, it becomes a topic of debate, and the Indian diplomacy has to face tough time protecting the interests of the country. And then they go on to say that how some filmmakers have made it a fashion, they've made it a norm to berate the feelings or the sentiments of the majority community and all of this. So and it doesn't happen in the West. In the West, nobody makes movies that berates Jesus Christ. This is completely false, because Spotlight.
There are a lot of
We all
movies.
know Spotlight.
Spotlight comes to mind very, very.
Very good,
Yeah.
heart-wrenching film.
Yeah.
One, the Best Picture at Academy Awards is
Yeah.
all about exposing pedophilia in Catholic
Yeah.
Church. But so what is interesting here is that all these terminologies, and the court has given no evidence that there have been an instance of our Ministry of External Affairs holding meetings with their foreign counterparts, explaining them that how we are not an intolerant country. Like, it doesn't happen. We don't know.
Yeah.
We have no evidence of Jai Shankar maybe meeting Biden or like Angela Merkel and telling them that, oh no, we are not intolerant. So,
Yeah.
just because some random person posted some tweet on Twitter, I don't think that happens. So, but I think what is more important is that all of this is a part of a larger narrative that is being built, that is, we are defaming the country. But this entire idea of defaming the country is nowhere in the law. There is nothing called defamation of the country. Like, there is no offense called defamation of the country. So we here see that new terminologies, and also they say political order. The term political order is also not envisaged in the offenses that are used against Purohit in this FIR. So we see that new terminologies are entering judicial orders, and these terminologies do not have any place in the law books. We don't find them in the law books. I studied law for 6 years. I never read about them. But we find these terminologies in the political discourse. In political discourse, we see time and again people using these terminologies like defaming the country or communal order, political order. So that's why I said that it's a political commentary, because a judicial order is not supposed to have political terms. It's supposed to have judicial terms. It's supposed to have judicial language. But instead of using judicial language, it is using political commentary and political terms.
Okay. So, given what the court has said so far and all that you've described as well, what Allahabad HCA has said as well, and the Supreme Court ruling as well, and not binding all the cases together, what has been the case so far for Aparna Purohit? Like, what are the actions which Amazon India has taken to basically try to extinguish this quote unquote controversy as such? So, have they tried to remove? Have they said that they'll remove the scenes, the objectionable scenes, or take down the series altogether? What actions have been taken so far? Can you walk us through that?
They have actually. I mean, even before the Allahabad High Court, Aparna Purohit's lawyer had argued that Amazon had taken down the objectionable scenes. They have also put a disclaimer. They have also later issued an apology that if there is some hurt or someone has been hurt or some loss has been caused, they're apologizing profusely. All of this was argued before the Allahabad High Court also, but the court completely neglected that. The court said it doesn't matter if you have a disclaimer. It doesn't matter you have apologized. It doesn't matter at all.
Wow.
Just because you
Okay.
have done it. Yeah. So, and also it becomes very interesting because it's an anticipatory bail. Like, it is
Yes.
not a trial. It's
Yes.
not a trial. You cannot pass judgments on the merits of the case in an anticipatory bail matter. And it is a law. You're not supposed to go into the merits of the case. And so even today in the Supreme Court, where this particular Allahabad High Court order has been challenged, Mukul
Yeah,
Rohatgi
let's do
argued, senior advocate Mukul Rohatgi said the same thing. He said that Amazon has apologized, has removed the content, and they are willing to make even more cuts to the content. So you have Amazon saying that we are willing to make more cuts to the show,
Yeah.
and they're saying you tell us what is objectionable and we'll cut it out. But I feel that's problematic. I feel that even if we don't end up sending Aparna to jail, even if we don't end up convicting her, we have we have actually harmed the freedom of expression already. We have created a chilling effect already, because you have Amazon here coming and saying that you tell us what to remove, we'll remove it. Now that has sort of
Yeah.
now it has a potential of becoming a precedent of a chilling effect, that tomorrow a person in a remotest village of UP will come and say, I find this objectionable. And
Yes.
then as a content creator, you'll have to remove it. So So some in law, there's a criminologist, Malcolm M. Feely, who quoted this very famous term called "process is the punishment."
Hmm.
And we see that is happening. So even if Purohit ends up not going to jail or ends up
Mhm.
not getting convicted, punishment has happened, and the punishment here is that the freedom of speech has been curbed and the content has
Yeah.
been removed. So that is where we sort of say that the judiciary should have been more proactive. The judiciary should have been more aware of.
And we also have to take cognizance of the fact that such a big company, content generation company, also included in that, like Amazon is taking such steps of telling the court that we will remove all the objectionable content that you see as objectionable without any clause as such. So I think that's also a very
Yeah,
big.
that's very important.
Yeah.
That's very important, Himmat,
Yeah.
because Amazon has money to have Mukul Rohati.
Yes.
We don't.
Yeah.
uh, I mean, tomorrow, if someone takes objection to this podcast, I don't think that Quint is going to pay Mukul Rohati to represent us. So,
Uh,
so I
let's
don't
keep our
think.
fingers crossed on that, Karan. Yes.
So I don't think that we have money to hire senior counsels representing us in the Supreme Court. So if someone with so much power and privilege
Hmm.
is sort of like taking a step back and saying we'll make the cuts,
Hmm.
well, it really puts all of us in a very, very precarious situation.
So, just summing up as well, what's next for the case? Like, is have we closed a chapter, or are we still like reading on? Where do we
I
see
think
this thing going forward?
I think the case has taken a very interesting turn now
Mhm.
because Supreme Court today, I mean yesterday they said they want to read the new OTT rules
Mhm.
uh, that had been promulgated under Section 79 of the Information Technology Act. And today, when the court came after reading the OTT rules, they said, well, there is no teeth in these rules
Mhm.
to prosecute. So
Uh,
the court was of the opinion that there is a need to screen the content on OTT platforms because they also show pornography.
uh-huh.
And the court is like, no, 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 you have to screen this. So, so now what happened is that today court came all prepared, reading the OTT rules, and the court is like, oh, but there is nothing in these OTT rules to prosecute. It has no teeth. It won't do anything. There is
Yeah.
nothing in these rules to prosecute, Mr. Union of India. You make a new law. You make a new law if you want to, because these rules, there's nothing to prosecute.
So
Which
the
is,
OTT rules which were passed recently, uh, are they just guidelines on what, or like
yes, they
green?
are just guidelines. They are just regulatory in nature. They are
Okay.
just regulatory in nature. They are not prosecutorial in nature. They are not penal.
Okay.
They are not
Right.
penal guidelines. They don't penalize. They are regulatory in nature.
All right.
Um, and and yes, I mean regulatory guidelines. They are not supposed to penalize. They're supposed to regulate, right?
Mhm.
And that's what the Solicitor General also informed the court. He said that these rules were made to strike a balance between not doing censorship and also promoting self-regulation. So they
Okay.
wanted to sort of strike a balance, and that's why these rules are created. But Solicitor General also said something today which I find very sinister. I mean, I'm very curious to
Mhm.
know what that means. He says that we will present a better draft tomorrow.
Okay.
Now, I don't get this. What is this better draft? Is this
Even
better?
though her anticipatory bail has been accepted, like she's been granted anticipatory bail, the Union of India still wants to go after her with a new draft of the OTT bill.
No, she has not been granted anticipatory bail as of yet. She has been given
Okay.
interim protection from arrest.
Interim
So,
protection.
yeah,
Okay.
so till the time Supreme Court decides this case, she will not be arrested.
All
So
right.
it's an interim protection. Interim protection is she got in Allahabad High Court also. Allahabad High Court
All
also
right.
said that till the time we give our judgment, she can't be arrested.
Okay.
So she has been given interim protection from arrest till the time Supreme Court decides this. But Supreme Court has decided to enlarge the scope of this case now. So the Supreme Court is like, this
Ah,
is no longer about Aparna Purohit, but we also have to comment on whether these OTT platforms need to be screened or not. And
okay.
people put in content there need to be prosecuted, which is very fascinating, Himmat, because there is there are a bunch of PILs already pending before another bench of the Supreme Court
Hmm.
that is looking into this matter of regulating OTT platforms.
Yes.
But despite that, this court somehow decided that no, 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 we need to sort of also talk about OTT regulation. Uh,
Okay.
so yeah, so and then Solicitor General said that we'll present a better draft, but I don't know what this better draft is. Is this better draft a different version of the present guidelines, or is it a completely different legislation that none of us in the country know about?
Hmm.
So So it's very fascinating. I mean,
Yeah, the case has evolved into
yeah, this case has now gone into various directions,
yeah,
and
various sections.
it's fascinating to see what we get from the
Yeah.
Supreme Court. It's not just Aparna Purohit now, it's also freedom of speech and expression, it's also OTT expression in the OTT platforms, regulation of these platforms, and how far we will go from
Mhm.
censorship to criminalization. Earlier it was about censorship. We saw Padmavat case.
Mhm.
Uh, we saw in different cases it bandit queen. We saw that it was the idea was to censor. If you don't agree with this, we'll censor you. But we
Mhm.
are now going a step ahead and we are criminalizing.
Okay.
We are now going, no, 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 censorship is it won't do enough. Now we'll criminalize you. We'll put you in jail.
Yeah.
And that is dangerous because you
Yeah.
are creating a crime when
Mhm.
there is no intention or malice.
Mhm.
A crime for censorship you don't have to prove a higher threshold of intention and malice, but for
Mhm.
crime you have to prove a higher threshold of intention and malice. So it's a very disturbing trend that we are going towards, and I'm very fascinated to see what Supreme Court will rule on this.
Yeah. I think this age-old debate of creative liberty versus regulation will keep on going. And well, thank you again for coming on the podcast. And I'm sure I'll see you again soon because given how, as you said as well, that they will come up with a new draft very, very soon or tomorrow, by the looks of it. You'll be on the podcast very soon again. So,
Thank you so much for having me. It's always great to
yeah.
talk about law in the context of society, politics, entertainment, and basically, taking the law outside of the courtroom, outside of the fraternity, and just having these discussions with people from various backgrounds and
Yeah.
talking law with them. It's absolutely liberating. Thank you for having me.
And I'm sure our listeners as well will be invigorated and also interested to know and understand what the Tandav case has gone through so far, and also the larger picture that the content we watch and the creative liberty which people enjoy on these platforms is at stake. So, to know more about the case against Amazon web series, head over to the Quint website. You can also catch all the updates regarding it on all our social media platforms. If you liked listening to this episode, please subscribe to The Big Story for episodic updates. We're available on Apple, Google Podcasts, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website, and for any feedback, please shoot an email to podcast@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.